Hello, everyone, and thank you for joining us for this webinar brought to you by Convey and Chartwell. My name is Russ Henderson. I'm Director of Research here at Chartwell, and I'd like to welcome all of you who are Chartwell members, as well as anybody who might be joining us for the first time. Our mission at Chartwell is to drive excellence in the utility industry by connecting the industry to solutions, and today's webinar is just one of the many ways that we achieve this goal. Keep in mind that if you have any questions during the webinar, we encourage you to submit those through the Q&A tool. And we'll get to as many of those as we can at the end of the hour. I know our presenters will very much appreciate those. A copy of today's slide deck is available in the resource list. And finally, today's webinar is being recorded. A link to the on-demand version of the webinar will be sent to you tomorrow when the recording is available for viewing. So let's talk a little bit about today's topic. Today, we're going to take a really practical, tactical look at what the new TCPA rules require and how to stay compliant. I know I'm personally very interested in this. I've been writing about TCPA in the context of outage communications in the utility industry for a number of years. And I'm very interested to hear what our presenters have to say today. We're going to learn how utilities can maintain fast, reliable communication during outages and service events without violating TCPA rules. Plus, we're going to first look at Enforce, Convey's new product built to automate compliance. A few introductions before we get started. Again, my name is Russ Henderson. I'm Director of Research here at Chartwell. Honored to serve as your host today. Behind the scenes is Gregory Griffin, who will be producing today's event. Joining us from Convey, we have Paul Watkins. Paul leads innovation strategy at Convey, where he focuses on AI-driven customer engagement solutions for utilities. With a background in both utility operations and digital transformation, Paul helps investor-owned and municipal utilities enhance outage communication, streamline workflows, and deliver measurable improvements in customer experience. And joining us from Copilevitz, Lam Raney, we have Bill Raney. Bill advises clients ranging from global corporations to independent service providers on First Amendment issues and compliance with federal and state telemarketing and privacy laws, including the CCPA, GDPR, and so forth. A certified information privacy professional. He has also appeared before the U.S. Supreme Court in Barr v. AAPC in 2020, where the court ruled in favor of his clients on a First Amendment challenge to the TCPA. So at this point, I am thrilled to turn things over to Paul and Bill. Thank you so much for being here. Very excited to hear what you guys have to say.
Thanks, Russ.
Thank you, Russ.
Yep, Bill, you're going to start us out, right?
Yes. It is a pleasure to be here today. It's a pleasure to work with Convey and Chartwell again. I've been called to this webinar a couple times now. I remember one in person and one online, so this is a good opportunity for me again, and I really appreciate it. What is the TCPA? The Telephone Consumer Protection Act was passed in 1992. It ultimately created the National Do Not Call list and was intended by Congress to protect consumers from abusive telemarketing. Text didn't exist at the time, but since then it's been broadened to include texts. At the end of the day, what I want to tell you today is that utilities are not the premier target for this the statute. What you're doing is much more along the lines of consumer support. Most of the TCPA will not apply to you, but it's important to comply with the parts that do. And the reason is it has been used in class actions for $500 to $1,500 per illegal text. That quickly could be catastrophic liability, and your companies normally are the deep pocket targets that the plaintiffs would look for, even for a technical violation. The FCC probably doesn't care what you're doing. Their motivation, we'd hope, is to protect consumers, to protect the marketplace for communications. Private plaintiffs, on the other hand, all they care about is money. And at $500 to $1,500 per text, there could be a lot of money for a campaign of any size. Here's next slide is an example of the cases that I've been working on recently that are solely abusive and about money. In Hewlett, iBuyDirect sent a text to a consumer 9 days after they'd opted out, sent a stop request. That is well within the 10 days, and they got sued anyway. And the reason is the language of the statute says a reasonable period of time not to exceed 10 days. So the plaintiff's argument here is, well, let's get into discovery. Let's figure out what's reasonable or not. And once they get in discovery, your litigation, your attorney bills are racking up very quickly. I used to say when I was a younger attorney that $1 of compliance was worth $10 of litigation. And I've since revised that to $1 of compliance worth $100 of litigation. It is in your best interest to not be a defendant at all, even if you're complying with the law. And so what Paul and I are going to recommend today are steps that raise you above the bar. So you're not a target. Even if you're close to the line, we don't want to be close to the line. We want to be on the safe side of this, so we're not a target of cases like Hewlett. As I said, TCPA violations can be $500 to $1,500 a call. The $1,500 is a treble damages standard for willful violations. Plaintiffs will argue that we're all creatures of free will, therefore anything is willful. That's not the legal standard, but that's the type of arguments we're going to face. And it acts as a multiplier. 1,000 texts or something could quickly be more than $1 million, and a big campaign could be billions of dollars. And the plaintiff's attorneys will say, okay, Bill, I agree with you. I only have 5% chance of winning. Multiply that times $1 billion, and what do you have? $50 million. So it is just an absolutely abusive area that you need to be very careful not to violate the TCPA. So what did the FCC do? In this regulation, it passed rules requiring opt-out for calls or texts, and calls and texts are treated the same under the TCPA, requiring that you honor any reasonable means of a consumer opting out. So it ruled that you can't specify the means. You can't say only call this 800 number or only send us a written request, etc. Any reasonable means is required to be honored. Further, they listed several specific words like stop, quit, end, revoke, etc. that you are automatically required to honor. So when you're designing your opt-out to a text or a call, it needs to be very broad to recognize misspellings, words that could be ambiguous, etc. In response to your texts or calls. And this is in response to your marketing texts or calls, as well as informational or transactional texts or calls. For example, an appointment reminder call, something like that would be informational. The law does not require that you include the opt-out means in the text. And the FCC specifically said that in the order, but it is in your best interest to do so. Something as simple as stop to stop or stop to end is what I recommend, because it gives you a presumption of being a good actor. Most consumers expect that language in there. By you including it, if you did get an abusive plaintiff later on, they'd have a hard argument saying they made a reasonable request. I had a case once where the person responded in some kind of fake old English and said, yea, verily, seesaw communications or whatever. And the court rejected that. It said, the text said stop to stop. You need to honor, stop to stop is sufficient. And this abusive case would not be permitted. Still got into litigation. We don't want litigation. We want to stay away from that. But by including the specific opt-out means, you're doing yourself a favor. So then, based on the industry's response to these rules, the FCC delayed the new opt-out rules until April 11th, 2026. It didn't change any of the substance. It just gave us a delay. So we have, 6 more months now to make sure that we're complying with these rules. So what did I say about a reasonable period of time not to exceed 10 days? I don't think 10 days is good enough. 10 days sets you up to be a target, like in Hewlett, the case I mentioned before. And in fact, the case that filed that case has filed at least 50 other cases against entities that honored the request but didn't honor it immediately. So if you have the technological ability to immediately honor the opt-out request, you should do so. Any failure to do so opens you up to a lawsuit. I'm not saying the lawsuit would be successful, but it does open you up for a lawsuit. The FCC also ruled that you're allowed to send a one-time confirmation. So you can send a confirmation saying, Mr. Raney, or whatever, did you intend to opt out of all communications, or do you want to limit your opt-out to marketing? We still would like to send you important informational texts. I'm not a skilled crafter of words, so I'm sure that that confirmation text could be better worded. But basically, if they don't respond, the stop is effective for all texts, with an exception of emergency texts. If they do opt out, you are allowed to say, okay, I want to limit that to marketing or whatever, and that confirmation message has to be sent within 5 minutes of the opt-out request. If you can't send that confirmation within 5 minutes, you shouldn't send it at all. The good thing I want to tell you today is the FCC has specifically ruled that emergency purposes calls are totally exempt from this. And emergency purposes is a little bit broader than a fire or something that might be a more limited hurricane or something like that. The FCC has ruled that an emergency purpose could be any notification of an impending or current power outages, including outages for scheduled maintenance, load management, or similar situations. So you're still allowed to make these types of texts, even if the consumer has opted out, and they will not subject you to TCPA liability. Now, they can't have marketing content or even information. They can only be for emergency. And if you have questions about what an emergency is, you should talk to your attorney. But know that the FCC has made specific rulings with regard to utilities that gives you some level of protection for outages, both scheduled and unplanned. These are the three classes of texts: commercial, which would be sales or advertising; informational, which would be an appointment reminder or similar; and emergency. And remember that emergency includes outages, so that's kind of important. You need to honor a reasonable opt-out request. So both those means that we specified, the stop, etc., or an immediate person on the phone saying, don't call me anymore. What does other reasonable means mean? Well, if you have an 800 number, or if you have a customer service email, whoever's answering that needs to be trained to recognize and honor opt-out request. If the stop comes to, for example, stop to stop, then that's presumed to be valid. But if you get a request in another way, like a letter or an email or something, there is still a rebuttable presumption that that request is honored, should be honored, is reasonable. So there really is a training and a record-keeping aspect of this that you need to implement on all inbound means of communication. The professional plaintiffs are sneaky. They will try to exploit gaps, and implementing training and record keeping is going to be a good thing to protect you. And it protects you in two ways. One, it protects you against the individual's claim. How much is the individual's claim? $500 to $1,500 call. Generally not a catastrophic liability issue. The class action is the most important thing. So if you've implemented these reasonable restrictions in training and somebody slips through because they send a certified letter to your office in Kansas City, that's not the end of the world. But you're not going to have a class of people sending certified letters. It's not going to be the catastrophic 1,000,000 times 500. And we want to reduce risks in all ways, both individual complaints and class complaints. Again, emergency calls are wholly exempt. Emergency might be broader than you think. And my recommendation is you honor stop requests immediately. And if you lack the technological ability to do so, you need to review the process, why it's not being honored immediately, and have somebody confirm that that process is reasonable. You need to review that from time to time, say every 6 months, to ensure that the system, that the process remains reasonable. And if you don't, you're opening yourself up to litigation like I described in the Hewlett case. And with that, I will pass it off to Paul. Thank you.
Thanks, Bill. That's been very informative. We appreciate you spending some time with us on that. We'll have time for questions after the presentation is complete. Wanted to talk with you a little bit about, what Convey is doing to kind of address some of these issues. As you can see in the past, there have been significant settlements against utilities. These are the class action lawsuits you're trying to avoid. Year over year, there's been increases in litigation around these topics. And with the new TCPA rules that are coming out, we're expecting this to continue or not, if not escalate in trends as you have more and more requirements for compliance with the TCPA rules. One thing we wanted to point out is that aggressive compliance does have its downsides in the sense that it limits your ability to communicate with your customers. Just remember that most of your customers want to hear from you, but in the age of affordability, most of your customers really value incentives and rebates and ways to save. So you want to try to preserve as much flexibility as possible communicating to the customers that want to hear from you. So don't throw out the baby with the bathwater, so to speak, when it comes to your TCPA type of strategy. So this is the reason we created the Enforce system. It goes well beyond just opt-out tracking. It can be tailored to your regulatory compliance strategies. So, every utility kind of has a different risk threshold when it comes to, what their compliance is going to look like and how they want to operate their outreach communications to customers. And so this particular product is designed specifically to adapt to a wide variety of different levels and thresholds that you would like to be able to provide. So Enforce helps you stay compliant in real time. It automates that process for you so that you don't have to have manual processes like Bill was describing. You don't have to wait that 9 days to be able to get your systems up to date. This system is designed to be done in real time and automated. It works across all your contact channels that are a part of this TCPA regulation. So that includes all your text messaging, SMS, RCS, as well as the voice communications. It serves as your single source of truth for this type of activity. It all is done in real time, so you don't really have to wait for a delay in terms of getting the system updated. And it protects you from that litigation. It shows that you're being proactive. It can prove specific complaints with its record-keeping process. You can pull up the history on certain things. And so all that really helps you protect you against really that deeper discovery that Bill is talking about. Once you get into that deeper discovery, obviously your costs to your utility escalate quite substantially. So what you really want to do is be able to cut it off right at the very beginning so these nuisance lawsuits don't escalate into something that is more expensive for you. So Enforce takes kind of a 4-pillar approach when it comes to how we use Enforce. It prioritizes privacy through consent revocation management and audit-ready repositories. It verifies the consent by filtering the messages across the different platforms to eliminate silos and centralized consent calculations. It ensures compliance with industry standards, including TCPA, portability, reassigned events, and do not call regulations. So the portability and reassignment is a piece of this that also is incorporated into our tool. We'll talk a little bit about that in the next slide. And it automates that consent revocation process with real-time monitoring, violation detection, and streamlined audit capabilities with centralized evidence management. So if you do get into a situation with a firm that has some kind of lawsuit against you, you can provide the documentation necessary so that you can show that you are complying and that particular case or incident either happened because of this reason or didn't happen at all. So just a little bit about, so how does Enforce work kind of under the covers, so to speak? So here you can see an example of our reassigned numbers process. We store at least 3 years of historical data about those different types of numbers that are reassigned. This allows Enforce to use that information directly and consume it internally. But we also recognize that it's not always our systems that need to be in compliance with this type of information. So we provide the ability to produce lists that can be synchronized with your other systems of record so that you can update those systems. So whether it's a do not call list, or it's this particular reassigned numbers list, you can get the information out of our systems and you can use it to help update your other core systems that you have throughout the utility. So, as you can see, Enforce is a complete system that manages both right party, right contact, the do not calls, the overall TCPA compliance. And so avoiding all these things does have benefits beyond just the regulatory compliance piece. If you're doing all those things properly, it should prevent calls coming into your call center and complaints from your customers for things that that you're just basically doing in your outbound call communication. So there's a lot of value beyond just the regulatory compliance. There's also some operational benefits that you ought to be looking at when you're building out your business case for something like this. So we have talked a little bit about what Enforce does. Let's kind of shift gears a little bit and talk about some of the features that we're planning for 2026. So what's coming for 2026 is more back office capabilities that will be available through Enforce. These are going to go directly to the specific phrases that are in the new rulings around reasonable means of detection. And so we have an intent detection system. It'll have the ability not only to detect the intent, but also detect misspelled intents, as well as other languages that customers might use in order to be able to opt out or to revoke consent. I think even in the legislation they had examples where they were using maybe French or Spanish as some of the different things that you have to be able to support as well. So the intent detection system will be able to do those types of things, both for the SMS and the RCS channels. It will return the intent type and a confidence factor. So those go back to your customer facing systems, and your systems can then use those two pieces of information to react to any of those unknown customer responses that may be occurring on those systems. So the system passes it to our Enforce system. Our Enforce system will tell your system, hey, this is the intent type, and here's the confidence that that is what this customer is intending on doing. And this particular solution will integrate directly into our Convey product lines. So this is something you can add on to the existing Convey products if you have those today. But if you don't, you can use our APIs to integrate this into your other tech stacks or other vendors that you have inside of your technology ecosystem. So don't feel like this is something that is just limited to Convey products. You can use it for any of the products that you're currently using today. In addition to that, we're looking at a dedicated consent IVR system. And this is really to support the one-way voice support. So one of the things you can kind of glean from the TCPA regulations is that, they went out of their way to look at both one-way types of communications as well as the two-way communications. What we know about one-way communications is they are limited because they are one-way. So they don't necessarily always capture customers' intent. So there have to be alternate means of being able to have a customer opt out of a one-way type of voice call or even a text message, perhaps. And so in those particular situations, we will have a dedicated IVR that you can use, and it can actually produce that one-time confirmation scenario that's also discussed in the ruling. So when the customer calls into that number, you have that option. You have the opportunity to limit the amount of opt-out or revoke consent that the customer is really intending on doing. And this is very important because you're trying to preserve as much ability to communicate to that customer for informational and marketing purposes as possible. So the system is already set up to do that. It integrates directly with our Enforce product. So if there is something that's captured that is a revoke consent or some type of level of opt-out, it goes automatically to Enforce. And then we have the ability to export that information so you can integrate that into your other systems of record so that your systems will be updated and maintained in a reasonable amount of time. So those are some of the new things that are coming in 2026. We're really excited about that. They will be available for compliance in April. So, there's not a lot of time left. We do expect that these types of capabilities are things we can stand up in weeks, not months. So you do have a little bit of time to make a decision, but we would encourage you to try to make a decision on what your strategy is going to be for TCPA compliance before the end of the year, so you have time to make sure you have everything in place for the full effect. So one other thing to keep in mind is that we're also going to be at your Emacs and Power Up events coming up next month. So be on the lookout for me and for Riot and everybody else at Convey will be there. Our booth is 109. We'll be having a couple different speaking engagements that are there as well. Would happy to talk with you more about what's going on with the TCPA regulations, what Enforce is able to do, and see what your future plans are for compliance for next year. So with that, I think I'm going to open it up to some Q&A. And so Greg, you want to take us away on the questions and answers from the audience?
Yeah, I can handle that. Looks like yeah, we got some questions here. Yeah, I want to thank you both. You both have presented and at Power Up and on webinars and other events, and very much looking forward to seeing you guys at Power Up and Emacs. I'll talk more about that later. I want to start off with a couple of questions here. Let me see. This one I think would be I'm going to start with a question that I've got for Paul. You talked a little bit about this already, but kind of balancing priorities when it comes to communications with customers. But what advice would you give to utilities balancing customer engagement goals, like program adoption, proactive messaging, these kinds of things, with this sort of heightened risk environment under a TCPA?
Well, I think it goes back to some of the things that Bill said in his part of the presentation, Russ, where you're talking about emergency communications versus everything else. And so, the thing that's really important to keep in mind is that this does not limit you from the emergency communication pieces. And there were some things that Bill was talking about in terms of the other classifications of messaging. So you had the marketing messaging and you had the informational messaging. So there are some nuances to your strategy in terms of, if I'm sending out marketing messaging and somebody opts out, that's going to affect, it's going to affect obviously my ability to market. If I'm doing informational messaging and I get an opt-out, that's going to affect both marketing and informational. So you've got to look at how you're doing that. Because the revoke consent is across all communications to that particular customer, that also means that your short code strategies that you have, where you've been collecting opt-outs by short code and limiting the amount of opt-out exposure that you're having, are not going to apply in the new TCPA world. So once you opt out of a short code, you've opted out of every other short code for those types of communications that the utility is using to communicate to their customers. So that's another part of the strategy you need to factor in.
Okay, that makes sense. Thank you, Paul. Here's a question for Bill. And you talked about the emergency purpose carve-outs. This may be a bit of a speculative question, but is there a possibility that those emergency purpose carve-outs might kind of shrink in the future? Do you think there are kind of some trends, some things that you've seen? Could regulators tighten definitions so that some current utility communications wouldn't really qualify?
I think it's possible, but it's not an area of law that's been changing really quickly. So a plaintiff trying to invest a whole bunch of money seems unlikely, trying to get that ruling, because I think the ruling, they're probably going to lose, and they have easier targets out there. It is so logical to think of a hospital and power being cut off, either planned or unplanned, and how lives are at stake, that your argument that this is an emergency is very strong. Now, if I was Red Cross and I was making an emergency fundraising appeal, well, that is not necessary for the health or safety of people. And even though that word emergency probably follows the English language, isn't going to fly in this situation. So I think that the utilities are pretty safe in this situation. And as Paul said, there's one way to be totally safe. Don't do it. I don't recommend that. I'm not that type of lawyer. I mean, your businesses, and you need to communicate with your customers for safety reasons, for reasons like scheduling appointments, and for marketing. I mean, that's okay. That's why businesses exist. I think the point Paul and I are trying to make is that you can do this. You just have to do it right. And don't be close to the edge. Be thoughtful. Your consumers want to hear from you. And so make your communications thoughtful, and they're not going to opt out.
Yeah, Russ, I would also add that some of the risk and threat to the utility is also coming from state-specific regulations. Bill had just brought up to us recently about some of our customers in Texas and some of the things that are going to occur with some of the Texas legislation. So there are other things that you as a utility have to look at, both on your state, from the state legislatures and what they're doing in conjunction with what the federal government's doing. So, you've got a very robust target-rich environment when it comes to different types of litigation risk that's occurring out there in the communication landscape.
Right, makes sense. All right, and then another question: are utilities required to track the revocations? That might be a word to. I'm not sure if that's the right word to use. At the account level, the phone number level. Is that something that's kind of spelled out, or is there a best practice there? And what happens if multiple household members are using the same number?
Bill, you want to take the first part of that? I'll take the second part.
I mean, yeah, I would be as broad as possible. We definitely have had abusive situations where spouse opts out, spouse A opts in, spouse B sues because he answered the call. I mean, it's pretty gross. And so at that level, I would try to be more conservative and less aggressive. If someone has identified themselves as not wanting the text, I would probably go, I mean, Paul can answer, I would probably go household level.
Yeah, so our systems, particularly for the new TCPA, are designed to at the number level for opt out for that particular utility. So if you revoke consent for all communications, that means that SMS, RCS, and voice will be blocked from having any kind of marketing or informational communications to that particular number, so that we're complying with revoking consent across all communication means. So that's how we'll handle it. At the account level, it's a little more of a judgment call on the utility side. If you want to go that far, I would encourage them not to do that, simply because collecting those contact numbers and those contact means is extremely difficult to do, and you want to hold on to as many of those as you possibly can. It may open you up to some people complaining, but if you have the right documentation, if you have the right systems of record recording what your activities are, I think you could defend that and say, look, this number did opt out. We opted them out of everything. This number, we've never received anything, and so we didn't know. I mean, why would we have done anything that was given to us as a contact means?
That's perfect. Thank you. It's another question that's coming here. How do you see the definition of reasonable revocation changing in the future with new channels like WhatsApp, push notifications, or RCS?
It's a training and a record keeping thing. My recommendation would be, before this goes into effect, to evaluate the outbound means of contact to consumers, your customers, if they're one-way or two-way, as Paul mentioned. Make sure that each of those outbound means contains an opt-out that's stated, and then evaluate your inbound means as well. And I gave the example of your office in Kansas City. That's probably a little bit beyond what's required, unless you're Kansas City Power and Light. I think it's changed names, Evergy. But if you have an inbound call center, if you have a customer service email, I would look at those and say, okay, do some statistical analysis. We got 1 million inbound contacts through these, and 97% of them were email, 800 number, or something else. And train the people who are getting that inbound contact to recognize an opt-out request. And if something happens on the fringes, then you're protected. A, because it might not win on the merits, and B, because it would be hard to certify as a class. You don't have to be perfect. I don't think anyone could be perfect, but doing some legwork ahead of time before you get a complaint, before there's any litigation, would be compliance dollars well spent, using that 1 to 100 ratio I used earlier. And Paul mentioned, the services his company can provide. It helps you if that review, that statistical review that I just described, is done by a third party, and it's essential that it's done prior to litigation for it to be admissible for your argument that you're a good actor. So do you have to be perfect? No one can be perfect, but creating some records ahead of time, periodically reviewing and revising those records to improve them if you can, shows that you're a good corporate citizen and would be a good client if somebody was trying to defend you in one of these things.
Perfect. All right. Let me see. We have another question here. If my company can't honor an opt-out request instantly for technical or logistical reasons, what should I do to show any delay is reasonable? You talked a little bit about this, Bill. Could you guys, maybe each of you guys talk about that one?
Yeah, Paul, go first.
Yeah, well, I mean, I think the thing you have to show is that you have a documented process that shows how it gets collected and how it goes through the process of ultimately being used to prevent future communications. And if you can show that within that 10-day window, I don't think you'll have any problems defending it. But you do have to have a documented process. Obviously, what Bill was suggesting about having it near time or real time kind of alleviates a lot of the problems that you would have if people are complaining, particularly if you're sending out a lot of communications. So if you're sending out, multiple communications a week and you have a 10-day process, customers may not recognize that it takes time to update. So if you can do it faster, that'll just avoid the frustration and the possible, litigation and nuisance lawsuits that might occur because your processes aren't as robust as they need to be. I'll hand it over to you, Bill. See what you have to say.
Yeah, and I think periodically reviewing the process to improve it would be important. If you just did that one time and then you got a suit 5 years later, it would be hard to argue that you're still being reasonable. The Hewlett case involved texts by an international company, consumer sales. I mean, they sell eyeglasses that were received over the Black Friday holiday. So there was an international communication and like a long holiday, and the judge ultimately said 9 days was reasonable. So it's not that you have to do it instantly. I mean, again, if you got a one-way communication, you couldn't do it instantly because somebody has to receive that inbound call and response and process it. But evaluating each of them, trying to make them all as good as possible, doesn't have to be perfect, and periodically reviewing that, every 6 months I think would be fine. Annually probably would be fine. Just to make sure that you are, creating a good record that you tried. And if you try, you don't have to be perfect.
Perfect. Thank you. This question is probably a little bit more for Bill because it kind of gets into the FCC and its whole approach to the TCPA. What is the difference between an advertising text and an informational text? So
it falls toward the advertising side. If you include any advertising content, like a coupon, $5 off to complete this survey, something like that, you're going to go into advertising. Courts have ruled that simply disclosing your name is not advertising. Plaintiffs did argue that. Here's a survey from IBM, and IBM gets sued, and they said you're implicitly trying to sell a product here, and that's not the case. Implicit is not enough. But if you're offering an incentive to buy, if you're offering a discount, if you're offering some kind of co-branding or marketing, that would fall into advertising. So you got to be very careful and realize that definition is going to be interpreted broadly. There have been many attempts at abuse through the years where things pretend to be non-marketing but are, and so you got to be more conservative than you think on that side.
Yeah, there have been some. There's certainly been some cases that have kind of blurred the lines. Certainly, got a couple more questions here before we wrap up. Let me see. Let's go with. Here's one on another one that's kind of future oriented. Could AI assisted communication, such as chatbots, proactive digital nudges, that sort of thing, trigger TCPA exposure in ways that utilities aren't currently expecting? I know that's, again, a little bit of a speculative question, but wondered if either of you guys would be interested in addressing that.
Yeah, I can go with that. I mean, we have chatbots that are pure SMS chatbots where you can have, and most of this is really oriented towards outbound communications, although I suppose you could apply it to inbound as well. But on the outbound communication, you send out a text message to a customer with some information, and behind the scenes is expecting you to respond back. That could be a chatbot, and that chatbot could be looking for keywords that might occur, or even just other words that are, intend to be opting out. So that's what our intent detection is designed to do, is to be able to look at those areas that go outside of the keywords and be able to determine whether or not the customer is asking you to be opted out of something. So I think as long, with the TCPA being kind of limited to texting and to voice calls, it would seem like, you don't have TCPA, at least Bill, unless correct me if I'm wrong, things like app push doesn't fall under TCPA. So a lot of these other applications rely on IP-based communications to get their messages out. So that type of thing, doesn't really apply a lot of times to the current legislation that's out there.
TCPA was passed before artificial intelligence. I mean, I think science fiction novels considered it, but it wasn't a reality 30 years ago. But it does have specific restrictions on the use of an automatic telephone dialing system or artificial or pre-recorded voice. And so artificial intelligence, artificial voice, that's pretty clearly in there. If you're going to use outbound calls using an artificial voice, including artificial intelligence, you should talk to your attorney. They are only allowed with prior express written signed consent if it's marketing, prior express consent for informational. Emergency is still exempt. And there have been plaintiffs who argued that standard applied to text, that a text was a pre-recorded voice, and they lost the word voice. So it's not so relevant on the SMS side, like Paul mentioned, but it would be relevant if you're using it for an outbound call, because it would be considered the same as a pre-recorded voice. The automatic telephone dialing system is something that was addressed by the Supreme Court in Facebook in 2021. And that term is limited to systems that create numbers to be called using a random or sequential number generator. So that's like 50-year-old technology. No one does that anymore. So don't think automatic telephone dialing system means a pre-recorded dialer. I mean, a predictive dialer. It doesn't. The Supreme Court has limited that, but we do need to be concerned with that artificial pre-recorded voice restriction, which still applies.
Excellent. Thank you. Yeah, I think the TCPA was initially passed to address junk faxes. That's how old it is, right? We have a question here from Robert Fecht with PSE&G. What other specific, I think he's asking you guys to kind of reiterate the specific changes to the TCPA that go into effect in April, and are there any others besides what's been discussed in this so far in our discussion?
I don't know if there's a link to the proposal. I could put it in the chat probably, I think. But I can read you what the
resources.
Okay, and it will be in a recording, and you can find the specific changes if you did a search for CG docket number 02-278, that's the FCC rule, and it is pretty limited. There's a lot of pages before they get to what they're actually changing, but what they're actually changing is the honor any reasonable means within 10 days, specifying words like stop, quit, end, revoke, opt out, cancel, or describe must be treated as valid, and that other means are presumed to be valid. So if you receive something and chose to reject it, my old English language earlier or something like that, you need to have a good reason why you're not, which is why those protections that Paul described, like misspelled words or not just limiting to those terms, is important because there's a presumption of validity. It also has the specific rule for that one-time confirmation message. And that's it. So it's any reasonable means plus the confirmation message. And then in the comments are where it specifically says emergency calls are exempt. And then it's an earlier ruling that I cited in one of my slides that specifically went into the power outages and how those are specifically emergency calls.
Yeah, I would say that we've already done work for some of the investor-owned utilities on compliance for these things. And so, in addition to what Bill's mentioning, we do have a dedicated IVR that we built just for this particular legislation. So that's something that, was commissioned by some other utilities for us to put in place because they had a bunch of outbound one-way voice communications and they needed a way to be able to collect revoke consent and opt out for that. So that was one thing that we also did, just maybe in the spirit of how to comply with that particular rule.
Excellent. Thank you, Paul. Thank you, Bill. Another question here. If I already have IVR and messaging systems, can I still use Enforce with these new features?
Very likely you can. Our systems use APIs, which are standard APIs to integrate with those systems. In the future, they will also support the new agent-to-agent agentic framework communication protocols. So if you have a more modern type of system that uses AI-based agentic frameworks, we will be able to support that too next year. But for now, everything we've done as far as integrations to other external systems will be done mostly through API.
Great, thank you. Final question is just kind of generally, is there anything else that you would like to share with our attendees here? You both have worked in this area for a long time. Perhaps there are interesting stories, case studies, examples that you would like to share, or just general advice or thoughts to kind of bring us home here.
I'll jump in first. Bill, you can wrap us up. I would say that when we were talking initially about the fact that year over year there's been an increase in the litigation levels of litigation that are going on around this subject, we've seen it directly from our clients. We get data requests for kind of particularly the records that are archived, because there's a lot of discovery that some of these data these lawsuits are churning up. So they want to go back 3 years, look at all the various activities the utility's done. A lot of that stuff we archive for them for long-term storage. So we're seeing a lot of that. It's definitely happening in specific pockets of the country. So if you're not in that area of the country where you're getting a lot of complaints, be thankful, but also be aware that they may be coming your way one day. But we're seeing a lot more of that type of activity. So this is a really important topic for our customers. Bill?
Well, I appreciate you both, and thank you for having me. I try to practice law in a way that says, yes, here's how you can do it, rather than no, don't do it. And I think Paul and I tried to say, you can do this. You are not the target of this statute. You are kind of a glancing blow at best. So you can do it. You just have to do it right. My final kind of philosophy, besides that one, is don't ignore complaints. If you get a spike, even if you know you're following the law, investigate. When I find a complaint, I consider it to be smoke. I look into that and see if there's any fire. And a lot of times there's not, and sometimes there is, and maybe that fire can be put out before it turns into a lawsuit or something serious. As I said at the beginning, not trying to be sky is falling, but this has potential catastrophic financial liability. The plaintiffs out there know it. The class action attorneys know it. And we would much rather snuff out a little tiny fire with $1 of compliance than $100 of litigation. So that's my philosophy.
Love it.
Perfect. Well, this has been fantastic, Paul, Bill. Appreciate you both very much. You guys have given us some very practical advice and tools. We've definitely focused here on the dangers, but especially we've talked about what you can and should do. And I think this has been really helpful for our audience. I know it's been helpful to me. In fact, I might be writing a new report here soon and be calling on you guys to contribute to that. So very much appreciate you guys.
Thank you, Russ. Thank you, Greg. Thank you, Bill.
All right. Appreciate you guys. All right. Before we wrap up here, I want us to remind everybody that Chartwell hosts webinars like this one regularly. So if today's conversation sparked ideas, gave you some useful information, you'll definitely want to keep an eye on what's coming up. Just head over to the events section of our website to see the full lineup. We have 2 webinars coming up next week on Wednesday on the 22nd. Wait a second. On the 20, sure that's the path. Yeah, there we go, on the 22nd. That's actually next month. Mark your calendars for improving customer satisfaction through advanced analytics and data strategies. In this webinar, Rajendra Acharya of Southern California Edison is going to show how advanced analytics and innovative data strategies uncover insights, streamline operations, and drive measurable improvements in customer satisfaction and experience. And then October the 29th, join us for a discussion of smarter authentication, stronger containment, powered by PinDrop. This webinar is going to feature John Kusiak of Duke Energy sharing the company's IVR transformation after PinDrop's implementation, highlighting enrollment growth, improved authentication for customers without social security numbers, key statistics, and agent feedback. So you don't want to miss those. And already we have mentioned, Paul's mentioned PowerUp and Emacs. I want to take a moment to invite you to join us. Both of these are coming up very shortly here in, I think, 9 days, October the 6th through the 9th at the Hyatt Regency in Dallas, Texas. We'd love to see you there in person. If you're not registered, it's not too late. You can register right now using the link on our webinar page. If you run into any issues, need any help getting signed up, let us know. We have an incredible lineup that is confirmed for this year. We've got Joel Austin as our keynote, talking about their transformational leadership. We're going to have PG&E talking about all the efforts that led to them winning our Customer Transformation Award. And at PowerUp, we're going to have Don Dagler, Centerpoint, talk about his work completely reworking Centerpoint's emergency management and resilience programs and procedures over the past 18 months there. He will have been there for 18 months doing all that hard work when the presentation comes. And then on day 2 of PowerUp, we're going to have a great presentation from LADWP talking about the Palisades fire and the other wildfires that they experienced earlier this year. Truly standpoint as well as emergency management standpoint, and every utility I think should hear that presentation. So we look forward to seeing you guys there. If you can find out more about these outstanding agendas on our website. And this concludes today's webinar on navigating the new TCPA rules. For more information on how Chartwell can connect you with the information your business needs for success, please visit us at www.chartwellinc.com or reach out to our VP of Sales, Tim Herrick. Thank you again for your participation, and we look forward to seeing you at a future Chartwell event. Take care.